Good afternoon, ladies and gentlemen, and welcome to the meeting of the Georges River Local Planning Panel for Thursday, the 16th of November 2023. My name is Sue Francis and I'm the chair of this panel, and the panel is currently steering from Georges River Council offices in McMahon Street, Hurstville. The panel members who make up the panel today are Deborah Laidlaw, expert panel member, Ian Armstrong, expert panel member, and Jenny Simpson being the community representative on the panel. And we're the panel who've been appointed by the Minister to determine the applications that are on the agenda today. First of all, I'd like to acknowledge the Georges River panel would like to acknowledge the Aboriginal people of the Eora Nation, who are the traditional custodians of the land and waters and sky in the Georges River area. We pay our respects to elders past and present and extend that respect to all Aboriginal and Torres Strait Islander peoples who live, work and meet on these lands. Now, just to let you know, we are live streaming, and the streamed event will be on Council's website and will be available for viewing. We have 5 registered speakers tonight, and they are speaking in relation to 2 items. So I have 5 speakers for 2 items. The 2 items that they're speaking on are 15 Woonona Parade, East Oakleigh, and I have 3 speakers for that, and they are Peter Hoycard, who's in the chambers with me here, Chris Hoycard, who's on Teams, and William Caravellas. And then the other item that I have speakers registered is for 113 Stewart Street, Blakehurst, and I have 2 speakers, John Krithanakis and Maram Hamawi, sorry. I'd just like to confirm that we have all had the opportunity to review the items on the agenda, and we're obliged to declare whether we have any conflicts of interest, and no panel member has disclosed any conflicts of interest in relation to any of the items on the agenda tonight. We've taken, just for your information, we've had site inspections of all the items on the agenda tonight, and just so as you know, that's 45 Kuroki Street, Penshurst, 15 Woonona Parade, East Oakleigh, 17 Planthurst Road, Carlton, 113 Stewart Street, Blakehurst, and 850 to 858 King George's Road, Hurstville. Although, as I said previously, I only have speakers in relation to 2 items. What that will mean is I will call those speakers in relation to those items, and you will have 3 minutes to make your representation, whether that's in person or online. And the panel may have some questions or clarifications they may wish to ask you. But then we will move on to the next speaker, and then we'll move on to the next item. No determinations will be made live. When we have finished hearing from representations, since we have no other representations in relation to the 3 other items, 1, 2, 3, 4, 5, we will close the meeting and deliberate on the matters before us. We will make our decisions tonight, and then council will put the decisions on the panel on the council's website within 2 to 3 days after this meeting. So, that being said, let's move on to our first speaker in relation to LPP 033 2023, and that's for 15 Woonona Parade, East Oakleigh, for modifications to an existing multi-dwelling housing. And I have Peter Hoycard. I think you're here. If you are here, would you like to come forward and put on the microphone and make your representation, please? Thank you, Peter.
Well, I'd like to thank you for letting me address this panel with my submission. I previously attended an LPP on Thursday, the 3rd of October 2019, which is here. And in this meeting, I was a speaker, and what happened, the determination was they had a conferred commencement, and that was the last 3 years, what I've got written down. At the result of this meeting, a grant and deferred commencement consent to our application subject to the conditions recommended. There was all these conditions, right, that was granted. And in this, there was 6 points on section A. This had to be completed within 3 years. This was in 3rd of October 2019. On the 2nd of September, I emailed the council. Has this been completed? This thing. And I have got this. Dear Peter, I can advise the deferred commencement conditions of this development consent have been satisfied. That was then. They're telling me the council says this, all these conditions have been satisfied. That was way back in September 21. My problem was the council then sent out a letter to the people on the 30th of September 21 regarding the building information certificate application. Unauthorised works, pouring of floor before construction certificate granted, no construction certificate, no certification of anything. Ground floor and first floor levels amended, drilling 2, 3 increased in size. So what has happened, this was done because this original development, which was done in 2018, had to be scaled back. It was scaled back because it was too big. So we went in 2019 where the builder had decreased things and made things smaller, and the main purpose, instead of having a double garage, he had 1.5 garages because he had scaled it back. But what's happened, we've been notified.
Sorry, just to let you know, we do know the history. We do know that the deferred commencement condition was satisfied, but it doesn't mean to say they're built in accordance with the rest of the conditions or the plans. So we're all familiar with that and we know what they've done.
So what he has done, he's increased the size. Because what's happened in this planning paper, it is, I've got it written down here, I should read off my notes. Too much paper here. In the planning paper, there is, the proposed development is subject to the provisions of Cogra Council Development Control KDCP 2013, which states all of the parking and travel, the water management site, the open spaces, the building heights, density, setbacks, all the bits and pieces that was originally put in. But guess what? The builder's changed it. He has increased it. We've been told that by the council. He has increased it. So all the calculations, all the, what have I written here? Don't apply. All these, and it's a table, these tables, all that is gone because he has increased his size from what this was. He went back in 2019, then he built unauthorised, no certificate, nothing, then he's increased it, and whatever was in here, this document is useless. It doesn't apply because there's no certificate, there's no authorisation. So that's my worry. As I said, the building was reduced. To do that, he chopped the garage off, he did other things. So what I'm saying is, all this Cogra Council KDCP 213 become null and void. All calculation sizes
Can I just say, we're aware of the history. We know what he's done. We know what the circumstances are.
Yeah,
We
but
know
I'm
the
telling you.
No, but I'm saying we know that. What I'd like to hear from you
Yeah.
is, do you have a specific problem with the specific things that he has built?
Well, the thing doesn't comply.
Yeah, no, we know that. But is there,
Sorry, it doesn't comply.
No.
I've just come along and I've just put a building up. I don't comply.
That's not what I'm asking you. I'm asking you whether specifically in relation to what he has done, we know what he's done.
That's
I'm
right.
not saying whether it's, I haven't said whether it's good or bad. I'm just saying we're aware of it. So I'm just wanting you not to use your time to tell us what we already know. What I want to know from you is,
I'm worried. That's what my concern is, to tell you what I wrote in when I wrote in, and this is what but what worries me is the way this has been done. In this time period, everything had to be done in 3 years from the date of 019. Now
he has to satisfy his deferred commencement condition within 3 years, which I understand. Council, tell me if I'm wrong, that he did. That's one element of the consent. That does not mean anything in relation to the unauthorised works, which everyone acknowledges he has done.
Yeah. So to have this, my worry is part of this agenda, he had to get approval to use the easement stormwater behind him. He hasn't. It's been 4 years.
You saying that's part of the deferred commencement
Yes,
condition?
part of the, we had to have this as part of the thing, which is part, he had to have legal permission to require easement to drain water from land subject 1 metre width from this running through 80th Street. That's part 1A. The applicant must require. He's built half the building and there's no stormwater connected.
Okay, we'll get clarification on that one.
Yeah. You might see that one of the other neighbours he's put in, and he lives next door. You can see when it rains, his pool is flooded, it's brown. It's absolutely just been demolished by the run of the water. Because there's no stormwater, there's no, the water just comes and just flows off. It's just been, but this applicant must acquire easement. I've asked the people at the back. No. Well, the next thing is, I've only just been aware of this, was this idea of the cars. I had ideas about the cars, as did the council. The council, way back, they had ideas about the cars and the turning circles and things. But there's 4 garages and car 1, 2, 3, 4. Car 1, you've got to reverse into the spot. Car 2, you've got to drive in. It sounds nice and simple, but I don't know how many people just drive their car with a friend. She's been reverse the car. She's been driving for 40 years. You buy unit 1, you've got to reverse into it. How many people will do that when they realise, well, it won't be that simple. It's not simple. It's very, very tight. Yeah. And that's it.
Thank you very much.
As I said, all the things we had, we had this other letter, which was in 28th of 3rd, 19, which was about the site coverage, the setbacks and all these other things, and just gone by the by. Just, he didn't care. He went to the LPP as I did, a determination was made, he ignored it. And as I said in my letter to the council, he built what he wanted to, not was agreed to. That's it. It's fact, you can see it. Thank you.
Thank you very much. I have Chris Hoykard on the online. Is that correct, Councillor? Okay, great. Thank you.
Hello, can you hear me?
Yes. Have you? Yep. Excellent. Thank you.
Can you hear me okay?
Yes, I can. 3 minutes.
Fantastic. Thank you very much. Thank you for the opportunity. Yeah, I've got numerous concerns. And if I can start off with the executive summary and particularly point 2, one thing that sort of became apparent to me when I was looking at it was that it states that the Development Assessment Officer states that MOD 2020-0206 was approved by Georges River LPP on the 16th of February 2021. So this is in point 2. When I actually have looked up the Georges River Council LPP, the infocouncil.biz, I can't actually see that there was a meeting held, an LPP meeting held on the 16th of February 2021. So I guess my question is, and then when I've looked at the actual approval, it clearly states that it was by delegated authority. So I'd like the panel to confirm that whether a meeting was held on the 16th of February, or perhaps who was responsible for approving MOD 2020-0206. So if I can say that's the first thing that's jumped out at me.
It was a delegated decision. It wasn't the local planning panel. So that's
okay. So the information, therefore, in the executive summary is incorrect.
Yes, it was the delegated determination of council staff. Okay.
So yeah, I just want to raise that information is incorrect from the development assessment planner. So, and obviously, in terms of the stormwater, I've got a DA in at the moment with Georges River Council, and I've been for 10 months trying to get access via my neighbours at the back, who have. I've proposed a legal deed. There's been an EGM and they've voted no. That happened on the 6th of April this year. Subsequently, I have been delayed in terms of getting approval because, like number 15, I need to drain, or I've been previously been required to drain to the easement until an alternate system had been devised. But the 1 to 5 Ada Street, who have the easement on their property, and obviously the water would be flowing through there, I just want to make you aware that they have refused, on the 6th of April 2023, have refused to provide me with legal access to that stormwater easement. Yeah. And obviously,
hold on. Can I just, I won't take from your time. I just want to clarify this because this is the second time that the issue of the deferred commencement being satisfied. Can anyone give me can council staff give us some information in relation to that? So what is the situation in terms of stormwater easements? Did they need an easement? And they have obtained an easement. Do you know whether it was an easement obtained through the courts or was it ADA? There was a deed of agreement. Okay, thank you. Chris?
Yes, yeah. Anyway, I'm just letting it known that 1 to 5 Ada Street have refused me. So, yeah. Furthermore, just in terms of my concerns, the other thing was in terms of the setbacks, which is point 70 of the executive summary. I do note that the assessment planner has got in there that the setbacks from the front is 4.5 to the main building facade. And therefore, I think it's listed as 4.895. But on the side setbacks, on the eastern it says 4.315 metres, and then on the western it says 3.95 metres. When I've actually looked at the drawings of the site plan, I can see that that for the eastern boundary, the minimum setback is 4.315, which is correct. However, when I look at the western boundary, and I know speaking to neighbours at 150 Hurstville Road, they've got the garages which are basically right onto their property, and that's 1100. Now, in terms of my development application, I know that I can't be within 1200 metres, 1200 mils or 1200 from either boundary, yet I can clearly see on the plan that there is, it says opening to be bricked in, which tells me that it's a significant wall, that it is 1100 from the side boundary, when in fact, the DCP clearly stipulates that it should be 4 metres from a side boundary. Furthermore, and again, this is more to do with my neighbours at the back, and hence why they're refusing to give me access to the easement. And what wasn't mentioned in the executive summary, there is no mention of the rear setback. Have I missed it? Looking at page 72. So my understanding was that the rear setback needs to be 6 metres. But when I look at the plans, I can see that the rear setback is significantly less than that. And that comes in at 3040 from the kitchen of dwelling number 4.
Can I just clarify, Chris, that you are commenting on plans that have been approved or against or the development as it relates to a brand new set of controls?
I wasn't aware that the positioning of the garages at 1100 off the side boundary was actually approved.
I'm just asking whether your comments are related to what has been approved.
Look, I'm just going off
with what's approved. Then that's one thing. Or are you comparing it to a set of controls that you might be being applied to, which I think are brand new?
No, I'm looking at the Georges River DCP for medium density property for multi-dwelling.
Yep.
And that's what I'm saying is I know for and when I've the setbacks and the assessment officer is correct in what she's put down for the side setbacks in terms of 4.5 metres from the front, and the side setback is 4 metres to the main building facade.
Yeah, sorry, it's quite pertinent because otherwise we're going to be talking at cross purposes.
Yeah.
This development was approved in October 2019. It would not have been considered having regard to the Georges River Development Control Plan 2021, unless staff can tell me I'm wrong. That's correct? Right, so if you're looking at a set of plans that have been advertised and trying to compare it to the DCP 21, it may not comply because that was not what it was tested against.
Okay. Well,
that's the only thing I'm saying.
Yeah. And I have looked at historic plans, and as far as I can tell, I'm just making making you aware that from the research that I've done, I could see that and in terms of 1100 from a side setback, I don't. Yeah. Anyway, I'm just raising that point.
Yep. No, it's okay.
Just for your consideration. But most importantly, I do want to note that on page 72, the development assessment planner has not made any mention whatsoever to the rear setback. Am I correct in that statement?
I will check with council whether there is a control in the DCP for a rear setback.
Yeah. I'm just again raising that, so it's clearly not listed in the on the executive summary. When I get down further, the other thing that has been there is what is required on the Georges River Council DA lodgement requirements matrix is a traffic and parking assessment report. And from the outset, one of my biggest concerns as a neighbour has been the limited number of parking spaces, and particularly the removal via the local planning panel or the delegated authority now to remove the visitor car space. So traffic and parking assessment report, I have not located one. through my submissions with the council, I've continually raised
I'm going to have to clarify this again. This
Yep.
is not an application for this is a very discrete matters that are being discussed here on
Yep.
this agenda. It is literally a balcony, some floor levels, some illegal enclosures of some elements of the back. The rest of the building, as far as the report before us is concerned, is as approved, and we don't have the luxury to revisit it. I'm just
Yes.
so what I don't want you to go on to things that we cannot change or have any power over, because it is already approved, rightly or wrongly. It is already approved. Okay.
I completely understand, and I guess this is an opportunity just for me to verbally articulate my perspective and my concerns with the yes, I understand what the purpose is, but I guess in terms of, I just want you to be made aware that in terms of the executive summary, there does appear to be some inaccuracies, and subsequently neighbours are going to be impacted by this. Look, if I don't want to take any much more of your time, one of the other things I do want to state in terms of my development, on the 30th of August 2023 this year, I received a letter regarding my DA. In that letter, the development assessment officer, and my DA application is for a single dwelling, 4-bedroom house. The development assessment planner who assessed the application states, the sitting, scale, bulk and massing of the proposed development, it is considered that the proposed development is excessive in bulk and scale, and as such, does not integrate with the locality. This particularly results in amenity issues to the neighbouring properties. So that was word for word, verbatim, in terms of what was stated from my DA. In contrast, a different development assessment officer for the same council has commented, this is for a property that's 14 metres from my boundary. The sitting, scale, bulk and massing of the proposed development are generally consistent with that anticipated for the site and represents a design that contributes positively to the future desired character of the area. The application is acceptable in this regard. I've got no idea how two people working for the same organisation, one person can deem a 4-bedroom single dwelling building as excessive in bulk and scale, and it has an FSR of 0.56. In contrast, when I've asked the development assessment planner for the FSR for the proposed dwelling, I was told that was confidential information. And furthermore, in contrast to mine, which is excessive in bulk, it says the sitting scale at bulk is consistent with the area. It is very, what as a resident and my neighbours, we are receiving very, very inconsistent messaging regarding
I
development.
understand your frustration, but this panel has not seen nor knows anything about your application, and I can understand why you might be frustrated, which is why I was trying to explain. This panel is not looking at the development that exists on the site in terms of whether it should be approved as an entity in and of itself. It is looking at very discrete elements of that construction. And only those discrete elements. And there are some issues that we have with that in terms of our power to deal with that, which I'll get to later on. But
I understand
we're not looking at it de novo, and we're not looking at yours at all. So we're not doing a comparison, because planning doesn't do comparisons. That's not what happens. And unfortunately, I will say there have been a changing in the controls since this particular site was developed, and no doubt your application, although I don't know that for a fact. So that is another factor that needs to be considered. It doesn't make it any easier for someone from the outside, I get that, but those are the things that need to be looked at. But
if I can just finish, and that's what I was trying to say, is in terms of my neighbours, and if I can say the broader community, decisions that are being made are being it's very confusing and frustrating. Yes, absolutely.
I I understand your frustration.
Yeah.
Don't get me. I do understand it, but we might be equally frustrated, but we only have certain power in relation to
Yeah.
this particular matter in front of us now, and it is very limited. I'm afraid you
Yeah,
might be
and,
able
and
to
it's,
tonight,
yeah, all,
but
all I'm asking is that you take that in consideration when in terms of your decision making.
as much as we can legally.
Thank you.
Okay, thank you. So the next speaker I have is William Caraballas, and he's online, I think.
Yeah, hi, can you hear me?
Yes.
If I can just make a couple of points in relation to some of the issues that the previous speakers brought up. Number one, with the easement, we had a unique situation in that there was an existing pipe that ran through that neighbouring property that connected our property with the street at the lower level. Therefore, when we approached them and we got a deed of agreement, it was basically to formalise that existing pipe through their site and in order to create that easement. So the pipe was actually existing, and all we did was formalise it, and that was all the council required, and hence we were able to satisfy that deferred commencement condition.
Sorry, William, are you talking on behalf of the application? Sorry, I don't have.
Yes, I am.
Who is who? Thank you very much. Thank you.
Yes, I am.
Thank
you. One other matter, just in terms of the that side setback, I think there's a bit of confusion in what actually happens there. That 1100 setback is to a retaining wall. If you have a look at the side elevation on that side, you will see that there's RLs showing what the top of those retaining walls are. I think they're about 900 above natural ground level. So there's a roofed area over that part of the courtyard which is paved. And therefore the actual building is set back about 4 meters from memory. So there's so the building is at 4 meters. There's then a covered area. So if someone wants to park a car in that area, they can then park it undercover, but there's no sidewalls as such, and it's open at the rear, and it's just a retaining wall at 1100. To retain the natural ground level, and then we've got the garbage bins, and then we have the parking. So
that's nothing to do with what's in front of us today, is it?
Okay, no, I just thought I'd explain.
No, I understand, but I really want to keep people focused.
Okay.
Because we can't do anything about all this other things. We can only deal with something that's in front of us, which gives us some challenges anyway, I'm afraid. But because some of the works that you're seeking relate to levels that aren't approved, which means we're not allowed to approve anything that's been built unlawfully, retrospectively.
Understand. All right, so does the panel have any questions that they would like to run past me?
That's probably a good idea. I'll ask the panel. Questions, anyone? No questions, William.
All right, if I can just say, in terms of the levels, from what was approved, out of the 4 dwellings, the dwelling number 1, the floor level actually went down, and then went down slightly, I think about 125 mil, if I'm not mistaken. And then the 3 dwellings behind were raised slightly by, I think, between 90 and 100 and
You there, William?
Yeah, hello.
Thank you.
Yeah, sorry, it cut out for some reason.
No,
so-
we lost you, William. But can I just say the very important thing that we need to understand is that this panel or even the council is not empowered to grant consent to any works that have already been built and or rely on works that have already been built. The only way they can be dealt with is through a building information certificate. And as I understand it, you do not have a modification approval or a building information certificate approved for your ground level slab, therefore your first level slab, and the other works. Is that correct? That's what council is telling us.
Yes, because council are waiting the outcome of this meeting to then deal with the building information certificate.
Now, unfortunately, it needs to be the other way around because we are not empowered under law to grant development consent to any unauthorised works retrospectively, regardless of what we think or don't think about them. So that is one of the fundamental things we have to deal with here. So to sort of cut to the chase, this matter would need to be dealt with through the building information certificate or any orders to remove structures if that's what happens in relation to this case, unfortunately. I
Understand.
Yeah, okay, thank you. So it's probably not, we don't need to go into what was approved in 2019 over which we can do nothing. We can only deal with ensuring that you lawfully built what was granted consent, which is the key thing here. Okay. Anything else you want to say to the panel?
No, under the circumstances, no.
Oh, unfortunately. Thank you very much. Okay. So
thank you.
Yes. Anything?
So I take it then we need to get the building information certificate approved and then come back to the panel.
Yes.
Would that be the case?
Simply put, yes.
Okay.
Yes.
All right.
Yeah.
Thank you very much.
Thank you.
Okay.
So what we will do now is that was the last speaker in relation to that particular item. We won't make any decisions on this now. We'll move on to 113 Stewart Street, Blakehurst. And we have two speakers coming in online. Is that correct? Yes. Fantastic. Correct. John is an objector. Thank you. Plans, please. This particular item. May I have them 113? Is John online? Oh, I'm so sorry. John, you have the floor, 3 minutes.
Thank you, panel. Thank you for the opportunity to speak today. So we are from 6 Pleasant Way, which is 3 properties to the north of the subject DA. Also on page 149 of the document provided. First of all, I wanted to state that we're not actually against the development itself, but we just wanted to put a couple of our points forward. The way our street actually bends, Pleasant Way, our property doesn't face due west. It actually faces southwest. So as you can see on the picture on page 149, our property faces towards the subject DA property. So what happens is the
the property bends, as the street bends around, our view goes directly through that particular property. The other thing is the RLs on the properties on Pleasant Way are much lower than what they are on Stewart Street. It's a downhill. So the angle of those properties there, including my own property, it's a lot flatter than what it is on Stewart Street, where they're a lot higher and the angle is from a much higher point. I guess the issue that we have at this point is, and I want to hone in on the fourth step of the tenacity case, I guess, and in particular item 98 that talks about the reasonableness of the proposal, right? So again, we're not against the proposal, and I believe that the actual DA can be changed slightly to allow for competing parties to actually have a desired outcome here, right? And the biggest issue is the western wall on page 205. The western wall of the proposed development is pretty much the whole way across the actual building line at the moment. And it's the component that's non-compliant that we're concerned about, because that is part of the southern directional view that we actually will have cut off. Now, again, I'm only complaining about the non-compliant portion, which I believe to be quite significant. I think in council's documentation, they refer to it as being non-significant or not unreasonable, maybe the terminology that they use. But the fact that we're here in front of the LPP is because it is significant. It's between 9 and 15%. And at its peak at 1,390 millimetres, it's 15% of the actual building height limit. That significant component, which is that western wall, and as you can see, the way our property faces, it is significant. And when I was speaking to council, one of the discussion points were which rooms are actually affected. And it's not just the rooms, I guess, but it's our pool deck is probably the most affected. And the proposal is quite close to that pool deck, and that the areas that we have that we use for entertainment on that floor. And again, I just feel that room, it's deemed they're calling it a parents' retreat, but it's quite a generous parents' retreat, considering the scale of the house already, right? So, I mean, I didn't do the math, but it looks like it's well over 100 square meters for a room. And I just feel like they could redesign that a little bit better, cut some of that western wall back, and bring that wall back to make it a little bit smaller, that room, to not impact us as much. So.
Okay, I think we understand your concern, John. Thank you for that. Any questions?
I just wanted to clarify.
Sorry, I can't hear you. I'm not sure what's happened, but I can't hear you.
Sorry, that's my fault. I didn't.
Okay.
I'm just looking at the drawings and in terms of the orientation of the building. When you say the western wall, do you mean the?
Sorry, the northern wall.
Elevation?
The northern wall. Yeah, the northern elevation. Yeah. Apologies.
Okay, and just to clarify, from the aerial photograph you referenced in the council officer's report, your property, if we're going from the subject property. Are you the sort of third one to the north, did you say?
Correct.
That's the one with the sort of lighter coloured roof that you can see?
Correct.
Okay.
Correct.
Yeah, thank you.
Thank you. Panel members, any other questions? No. No. Thank you. Thank you very much, John.
Okay. Thank you for that.
Thank you. Thank you. We'll go on to, is it Maram Hamari?
Yeah, it's actually Sean Hammer.
speaking?
Yeah,
Okay, that's
Sean
fine.
Hammer.
Apologies. My
Yeah,
apologies.
no, that's okay. Look, thanks
John, the floor is
for
yours.
thank you for allowing me to talk at this LPP. Look, I'm in a similar boat to John. I'm not against development whatsoever.
Where are you? Where are you? What number?
Yeah, pardon me. Yeah, we're from 6A,
You're
so we're
6A.
from
Okay.
yeah,
Yep.
we're from the next house over, John. I guess from our perspective, especially our kitchen and living area and one of our bedrooms at the back, we've got direct line of sight over the vegetation directly onto the existing roof of this property. Now, I'm not sure what's happened since the application's gone in, but it looks like this property in the last 2 weeks has put a brand new roof over the flat tarred roof. And just in terms of on page 181 of the LPP, you know, that kind of variation of over 10% up to 15% is quite significant. And what it does specifically for us, that window that they've got on the northern wall, that peers directly over the vegetation into our living area. So you know, if they were to come back and shrink the size of that, then the existing vegetation, the tree canopies, would actually cover that up. And it would also, because right now, as it stands, they're going to be obstructing some of the view that we enjoy. So that extra, I think I had the numbers over here. So effectively, it eats up the view on that side of our property of the water. Now, obviously, this property enjoys 180-degree views off every floor because of their location. But I was just wondering, because of the size of this parent tree, why did it need to be that big? And for it to be approved in terms of it being out of compliance, as you can see on pages 182, like where that yellow component is, you know, we wouldn't have any issues or objections if that whole yellow part was the part that was condensed or removed from the DA, because it just seems like it's enlarged and it's a bulky building, and I'm not sure why a property that has unobstructed views like that does need to breach the planning regulations, considering the size that they're trying to achieve. You know, from our perspective.
I understand what you're saying, Sean. I understand the concerns, so we'll bear those in mind. Has anyone got any questions for Sean? Panel members? No. Yeah, no. Sean, do you have any other issues other than that?
No, it's just
on that northern elevation.
Yeah, correct. It's just the breach of the height regulations.
Okay, thank you. Fair enough. Okay, now I just want to check with this council. Do we have any other speakers on these items? If we have any speakers on any other items, no, that was he was on behalf of. So no other speakers, notwithstanding we do have people in the audience that I don't think have spoken. They're just here to listen. How wonderful, how fantastic. Wow, how exhausting. Okay, so that being it, we have no more speakers. So what I will do, therefore, is close the meeting at whatever the time is now, 4:53 according to my device, and then we will deliberate on the items. and you have to go now.